Kaylin.
Good morning.
Yeah, we see a lot of the craziest stuff in real estate when people get to closings, don't we?
We sure do.
Yeah, I think the craziest thing is when people die. Nobody ever knows what to do, right? It's like sheer panic when people die. Do they need to probate their estate? Do they not need to probate their estate? What are some ways to kind of get around that? And so I think one of the best things that anybody can do is, what do we always tell them to do?
Get an attorney.
Get an attorney. And we have one of the best attorneys on this podcast. And we are not biased at all whatsoever. But we have on this podcast one of our favorite friends and attorneys, Jen Jaschen, too. So welcome, Jen, to our podcast today.
Everyone, thanks for having me.
Perfect. Well, we kind of wanted to bring this up because one of the biggest things we get as agents, as closing agents, as normal people just out in the public too, is how do we plan for succession when somebody passes away, or how do we start thinking about that before it becomes an issue too? So we would love to get your professional feedback too, always with a disclaimer that this is not legal advice, right? That's what you guys always have to say.
Yes, I love it.
Yeah. And so we just want to kind of hear again from the very 10,000 foot level, what does this look like for somebody too? But first, tell us a little bit about yourself.
Sure. So, hi everyone. If you've never met me, or maybe you've seen my name on a title opinion, here I am in the flesh. I do really exist, even though it seems like sometimes I'm behind closed doors. But my name's Jen Jaschen. I have a law practice in Cedar Falls, Iowa, and I do a lot of real estate. In the past, after I graduated from Drake Law School, I worked in private practice in Des Moines for several years, doing a variety of things. I was at a medium-sized firm, and as the new law school graduate, you're bottom on the totem pole. So my exposure was very large with litigation, insurance, defense, some of this transactional law, contracts, estate planning, real estate, the list goes on. And then in between those two, I worked as an attorney on staff for Home Services of Iowa. And the companies that they own sound more familiar, like Iowa Title Company, BHHS First Realty, Iowa Realty. So I gave a lot of legal guidance to real estate agents and loved that so much. I was mostly on the phone all the time, just putting out fires. So I was like a real estate firefighter.
We need to get you a hat. That's what we need. You need a fire hat.
There you go. Whenever an attorney is involved, something is on fire. Like, it is too late. It's past the point of no return. That's usually when we get involved. So you will hear my guidance coming out to get us involved before that stage.
Love it. And we love that too, because again, usually when it hits our desk at the closing table, it's already, the fire is way past due. We got to be those extinguishers is what we need then too at that point too. What's your favorite part about law that you've done? So you've done a lot of different law. Is real estate your favorite?
I do love.
You can be honest. This is an honest podcast.
Right. Honest. To be real clear about it, it's true. I don't know what it is about real estate. Sometimes I think about it, but I just really do love this area. I appreciate that almost all the time, everyone is winning. The buyer's winning, the seller's winning. Everyone's happy. It's an exciting exchange. I think real estate is fun. Every parcel is different. Every property is different. It's fun to look at homes. I definitely have strayed away from, never did criminal law. Don't waste your phone call on me is what I tell people. It's not worth it. And litigation is definitely not my favorite. There's so much fighting, but I appreciate the background that I have in it.
Yeah. So Kaylin, if you have one bail call and you're in jail, do not call Jen. She's not going to
Don't call Jen.
No,
She's told me that more than once too.
See? Because it's so true. Don't waste your 2 a.m. calling me. I'm not going to answer. My phone's off.
Love it. Yeah. So we're here to talk about a little bit of succession planning. So like you said, get involved early too. And so that has to do a lot with, again, when you're buying a home too. What's your succession plan with that? And it starts literally from the very beginning too, of whether you're taking title in a different way, whether you're doing title as joint tenants versus tenants in common, because that is all a part of that succession too. And not a lot of people realize that when they're buying a home, that this is a super important part too. So tell us what some of the top things to think about when you're planning for succession in real estate.
Sure. At the outset, I feel like if you're one of the most common frequent general buyers, knowing whether you're buying as a joint tenant or tenant in common is key. So generally people are in a relationship and they have children. So the first question is, in terms of joint tenant versus tenant in common, joint tenancy means if we take as joint tenants, then if one of us dies, the other one automatically becomes the full owner of the property. Right? Family dynamics are changing and we have blended families. We have typical, I don't know if I want to call it typical, that's not even true anymore, but historic families maybe, where it's a husband and wife and their own kids. So we want that surviving spouse to automatically get that property. But if we have a blended family, that might not be the case. We might want to do a tenant in common where even if one of us dies, we get a 50-50 split so that my half can go to my kids and your half can go to your kids, or some other arrangement. But generally that simple answer helps us start the succession planning conversation for most families. And then succession planning can get much more complicated if we're in our elder years and we're worried about how this property will transfer to our kids. We can meet with an attorney and a tax professional to talk about transferring that. I don't even know those are like the main ones that I see. If there are other topics that really stick out. But when we have, or if we just have a unique ownership, maybe we have a rental property, we can look at LLCs, we can look at trusts for people who are worried about putting limits on things. So there are a lot of options out there.
You bet. I think one of the, I've been doing this a while, and one of the scariest things that I always see is when you have a boyfriend and girlfriend just got together. And guess what? We buying a house together. Great. How are you going to take title? And they're like, oh yeah, joint tenants, not a big deal. And then they break up. And then what happens, Jen?
Well, then we have to work on the cleanup. It really depends on how well they're getting along. Typically, when people break up, we are not cooperative. The same with the divorce situation. Nobody's excited about it. And when our relationships start to deteriorate and we move on to the next one, we need to be mindful of how we've set that up and kind of think ahead to be wise in knowing that it's what we want. So joint tenants versus tenants in common is key to sort out then. Or if we're at that breakup or divorce stage, knowing that, hey, I should really take care of the title to this property so that if something happens to me hit by a bus, then everything is going where it should. So we can do quick claim deeds and fix or repair and change that. It's not a big deal. It's just a matter of reaching out to your lawyer to get that fixed for you.
Yeah, another thing we see too is if I'm going to just use boyfriend and girlfriend again as an example too, but you have girlfriend who's buying the house and says, I want boyfriend on title, but he's not paying any mortgage, he's not doing anything. And then guess what? He's a deadbeat and moves out, and you're stuck with him on that property. And sometimes, again, it takes money or other things to get them off of that too. And so, again, just planning ahead too. Like everybody's well and great until they aren't well and great. Yeah, I would say it's like insurance. You never need insurance until you need it. So let's plan ahead to make sure that you have those things in place too. Yeah, all the things we get to get involved in, Jen. It's great, right? It's great.
It is great. It keeps it interesting. So I appreciate that aspect. And it's always fun to help people, but there are steps along the way that are no fun. Like if you have a situation as you just described, it's so sticky and people lose and are upset, but at least you get through to the other side.
Yeah, I love it. So in tenants in common, do you have to take title as 50-50? Like I own this half, you own this half?
Right. Good question. No, you legally don't. We can put percentages on it. We just say 50-50 because it is what we most often see. I would say more than 90% of the time. But I have seen situations where people have less than that 50-50 share, We just simply need to clarify it at the outset on the deed, what that percentage ownership is.
Love it. And so let's say it does not say a tenancy on the deed. So we see deeds that just come and say Bob Smith and Mary Smith. And I don't know why those two names always come to me, but that if I'm using an example of Bob and Mary, they get thrown under the bus every time, whether it's good or bad too. If they do not have a tenancy unlisted on the deed, does it refer back to joint tenants? Does it go to tenants in common? How does that reflect?
Good question. I should have pulled the code before we had this podcast. But generally, if there's nothing listed, then the Iowa code will tell us how the title is taken, what the standard fallback is. So I don't want to go from memory because my memory could be the exact opposite of what the code is.
It's okay. I won't throw you in there either. No, not at all. So what are a few different ways you can title a home? So we talked about tenants in common. We talked about joint tenancy. What are some other things that you actually kind of see going along?
Sure. Sometimes when we have those clients in the elder years, we'll see what we call life estates. So that is when a person reserves ownership of the property during their life. So it's their estate during their life. And then once they die, it will auto transfer to who we call the remainder men. So whoever is listed as after that life estate. So that's a unique way to retain ownership of the property and control, but as soon as you're gone, it's going to those subsequent owners. I think one thing people don't, there's so many, I'll roll back and say there are so many things to evaluate, which is why I always encourage people to talk to a legal professional as you are. That sounds well and great. I want a life estate and we pass it on to the next generation, easy peasy. But what if during my life I decide to sell that property and move to a smaller home to downsize or move to a community where there are other people my age and more activities and more freedom? Well, all of a sudden I have to get signatures on the deed from myself and all of my remainder men and their spouses.
Yep.
And we have had situations like that where you have 12 people signing the deed, and if one person doesn't agree, it can make it a nightmare. So those are, we just kind of went down the rabbit hole with a life estate, but that's something to keep in mind, and that's something we see. Those LLCs I talked about are another way that people are taking title, whether it's to give them some business liability protection, some privacy, or just to keep it in a separate entity for tax purposes. And then another route I'm also seeing are trusts. Some people are using trusts for privacy, maybe for tax avoidance, but that's not as critical, not as common right now because the tax laws are very, I'm going to say forgiving in terms of federal estate tax exemption. But people are still using those for privacy or to put restrictions on the property for future generational use.
Yeah, and I would say in the past, maybe 2 to 3 years, we've really seen an influx of trusts. I don't know what happened in that thing, but now it's like everybody and their mom wants to do a trust, like literally, which again, it comes with more documentation that we're required to have in our files and more questions that we have to ask in that space too. What would you say are some of the common questions that you ask people when they come to talk to you about succession planning? What are some common questions that you ask to make sure that they are setting themselves up for success in their succession? I'm gonna force myself to say this. I gotta do it. So here we go. What are some successful succession planning questions?
I love it. The number one question that I ask people is, what is your goal, or what are your goals? Everyone has different goals and reasons for what they want the outcome to be, and that's really going to impact which path we choose to go down. So sometimes people's goals are tax related. I'd say that's a very common one. And then we need involvement with that tax professional as well. We'll talk about how big is your estate? Are we close to that federal estate tax exemption? Are we worried about, what other taxes are we worried about paying? Inheritance tax or generation skipping tax? There are a lot of taxes that apply, not just income. And I'm not a tax professional. I'm keeping that in someone else's boat. I'm driving the legal boat, but we can work together to make sure that those goals are met. So some people are worried about transferring their property before they might have to go to a nursing home. They're worried about avoiding the Medicaid and the Iowa the Iowa taxes, not taxes, but paying for that, essentially losing the home to pay for nursing home care. And one key thing that we talk about related to that is there's a 5-year look back period. So any gifts you give within 5 years before applying for Medicaid are included. And when we retitle property for no money exchanged, then that's a gift. It also can incur a gift tax return. And people can be surprised to hear about that we need to notify the government that you gave a large gift of naming your kids as remainder men with a life estate, or adding your kids to an LLC for free, or just putting their names on title as joint tenants with your name so that they get title when you die. So overall, we'll circle back to, what is your goal? Is it to get the title of the property to the kids? Is it to avoid that Medicaid payment for the nursing home? Is it because you have farmland and you want to make sure your family doesn't sell it as soon as you die? You want it to continue on for the next generation? We just evaluate all those situations to determine which route is the best way to take.
Yeah, and I will say again, a lot of people wait till the last minute to do it. Just like you said that, like, oh, grandma's going into the nursing home, let's quick claim deed this out so we don't have to do it. And it's like, you better talk to an attorney about that. Like, again, we know enough to be dangerous, so we're just going to send you an attorney, because again, you need all of the information to make sure you're making a good choice too.
Yeah, it seems simple at the outset, but things get very complicated, especially with all those levels of tax we just mentioned. It's most important to know what the goal is so that we can best advise you on to how to get there.
You bet. But I'm going to be honest, if anyone that gives me a gift of a house or farmland, I'm going to take it. Like, we're just being honest, like, I'll figure out the tax portion of it. Go ahead. Like, we'll figure this out together. I'm sure you ladies would be the same.
Right? How do you decline?
Love it. So let's talk about, again, you can do some of this through your will too, correct?
You can. So when we talk about trusts, there are 2 types of trusts. There are trusts that exist during your life, which we call inter vivos trusts. So that means while I'm alive and here, I'm going to raise my hand up high. There's a trust here and I'm here, I'm human, here's my trust. I tell clients to look at that like an LLC. You're setting it up, it exists, it's functioning, kind of like a business. Then the other type of trust is a testamentary trust, which means it exists once I die. So once my will has been probated, then that trust is created, and whatever properties, because we're talking about real estate or other assets I put into that trust, they go in upon my death and not today. Today I can put in whatever assets I want into an existing trust. So that testamentary trust doesn't exactly exist until my death. So you can plan ahead with that as a tool as well. One thing that clients are always interested in hearing from me about trusts and LLCs that they create today is the fact that because it's an actual business that's separate from you, it's going to have to pay a tax return. You need to file a tax return. You need to keep track of all of its assets and business management, which can become more work that someone doesn't really want. Again, back to the goals. If my goal is A, and it's super, super important for me that my kids don't sell that land, then I don't mind doing the legwork to set up that trust or LLC now, because overall I get the goal that I wanted.
Yeah, love it too. And some people set it up and don't realize they really don't need to set it up if they don't get the right guidance too. We have a lot of people that say like, oh, I need a trust or I need an LLC. And it's like, do you? Do you really? Like, or again, like you said, are you just causing yourself more work and headache too? And the other thing with those two, at least with LLCs for sure, is you have to remember you still need to keep that active as you go along too. So many people forget about it or don't file their biennial reports, and then we have to get them to redo it or reactivate it too. And so again, sometimes people don't think about the whole picture of what needs to go on here too. I got so excited, I swung my arms and I hit my microphone. So sorry if you're making a noise. So excited and so into this too. So
it does sound like a great idea when you're keeping up with the Joneses. I get that a lot. People come in and say, so and so told me I had to get a trust or an LLC, so I wanted to meet with
word
you.
of mouth.
Or my neighbor has one, so I thought I should too. Right? And again, it comes back to the simplicity of what is your goal?
Yeah.
whether you do need that or not.
Yeah, love it. Kaylin, do you have any questions? I talk. Kaylin needs to just like shut me up. She needs to like really be on me about stuff too. Yeah.
I don't think so, no.
Yeah. Like what?
I think this was great even for me and Jess to hear from you.
Yeah.
I mean, we see you almost every week, but it's good to hear like the legal side of things also. Then anytime I ever have a question, I just yell at Jen because she's next door.
Yeah. And by yell, she literally does mean yell. They don't call.
I do mean yell.
Yeah. It just works out so well. I know, because by the time I see you again, we're so far down that rabbit hole of now we're dealing with the consequence of our choice, whether good or bad.
Yep.
And when I'm meeting with a client, it's to prep and prepare for that. And then again, sometimes in those situations, everything is done and managed so it smoothly rolls into the real estate transaction when that happens.
Now, tell me a little, we talked a little bit about wills too. Like, when do you recommend somebody sets, I know I'm going kind of down another rabbit hole, but it kind of leads to other examples and situations too. Like, when do you suggest somebody sets up a will? You know, so many people wait till they have kids, although they have all these other assets and other things, but they're like, oh, I have a kid, now I need to do it. Or their kid's going to college and I'm like, oh my gosh, this is a long time from now. Like, you should have had one a long time ago. Like, but what do you typically suggest? When do people get wills?
Right? That's a good question. I don't know if anyone's ever asked me that. Again, it just depends. It varies with everyone in their life stage. But if I'm thinking about how I even want to answer it, I think it's always a good time to get a will. There's never a bad time. It's an overwhelming topic for people. They don't want to think about it. It's weird for me because I think and talk about it all the time. So I'm just immune to it, or I'm neutral to it. It's easy peasy. And then I feel awkward sometimes when I'm talking with clients and we're just, all right, what if you die? What if they die? And I'm like, okay, I should be a little bit more emotional.
You should be excited about this. We should be more somber, maybe.
Sorry. But I think it's always a good time to write a will and make sure you have something in place. If we have young children, I'm going to throw an especially word on that. Like, if you have young children, it is especially a good time to get a will, because if something happened to you, both you and the other parent of your children, and these young children are left with money, that money will go into a conservatorship until they're 18. They can still use that money, and an adult will help them. Basically, another family member or a close friend will help them. But as soon as they're 18, they get to cash out. And if you think of your life insurance policy, your home, your bank accounts, your 401k, all of that liquidated, and get that portion. So if you had one child, they'd get 100% of what's left, or 4 kids, they're 25%. It can be a lot of money. And I can tell you lots of things I would have spent that on when I was 18. Would have started with a car, maybe a good closet fill, and then what's left, you know? So it's really great at that point. I talk to my parents of young children to establish what we talked about, that testamentary trust, to put limits on when that money is really going to be paid out to our young children. And as young parents, we think about, okay, I was this much responsible at this age, so those kids can have either this lump sum, maybe $10,000 when they're 18, or 25% of their share, and then we space it out, maybe like 20, 21, 25, 30. I see everything. We're very creative with that planning, and attorneys can be, but this way, I think parents of young children feel better knowing, okay, they're not just going to get all this money and blow it at 18. They can space it out and buy a house and pay for college and build a life, be more responsible with that money.
Absolutely. If it's up to me, my kids would never get it. Like, okay, you got to wait till you're like 50. Okay. That's when you're going to get this sucker.
Honestly, like, people want their kids to build themselves and not be so reliant on that huge inheritance they may have gotten because they lost their parents at a young age, to build themselves, and then they're finally rewarded later in life. And it's there. They just have to meet those needs. So originally the question was, when do you have to set up a will? But it's always a good time, especially if maybe you have a serious significant other, but you're not legally married. well, that person is entitled to nothing
That's
under
cool.
the law. So it would be very important for you to set up a will to make sure that they're given what you want to give them. Or if you have non-family members that you want to get things, right?
Yeah.
That's a good way to establish that.
Or even if you want your kids to go someplace too, if you have young kids, if you don't want them to go with a family member, but want them to be set with somebody else that you want to be a guardian who's agreed to it too. Like that's a huge thing to think about.
Yeah, absolutely. So anytime in your life especially when key events happen, like key event of getting married, a key event of having a child, a key event of getting a divorce, those are all things, or losing a spouse.
Yeah.
All great times to look at your will and revise that to make sure it's really your assets are going where you want them to go.
Yeah. And I think that's a key is like what you set in stone now doesn't have to be there forever. You can revise it at any time. Like if something changes, some life circumstance, you can change that too.
You can, and you can do a big change by writing a whole new one, or you can do a small change. People know the word amendment. We refer to it as a codicil to your will, and that can just label, if everything else is the same and you just want to change the executor that you're designating, easy peasy, and it's updated.
Yeah. Speaking of executors, and we talked about wills, and now wrapping it back to real estate, because this is like a typical MO for Jess, who just gets on a tangent and starts asking questions about 500 other things. But bring it back to that. One of the things that we typically see when we go to sell a home too, if there is a will, if it has court approval to sell, or if the executors have the right to sell. So can you just kind of describe those two things? Because I don't think that people really realize what those two things actually mean and why we need it too.
Right. When I'm reading an abstract and I see that the estate is the seller, there are a few key things that I'm looking for. The first thing I want to know is who's in charge of the estate. So that's either going to be, the word we typically hear is executor, and that's what people refer to it as. But another name for that could be administrator. It's just a legal tip-off to me that if someone has an administrator, it means that they died with no will. An executor means there was a will and it's specifically named that person or someone else. So first I'm going to look for who's in charge. The second thing I'm going to look for is whether that person has authority to sell the real estate. That authority is not just existing because you have the title. It has to be given. It can either be given in the will. So if I have an executor, then I know there's a possibility that that was given in the will. If it's an administrator, I know they automatically don't because there was no will, right? So I look for whether that authority exists. It either comes from the will, as I said, which we draft in as attorneys to make it easier.
It's so much easier.
Unless you don't want them to have that authority, right? Again, goals. How many heirs do we have? Maybe we don't want them to have that authority. The other place it comes from is the court. So if they don't have authority from the will, then we have to request that authority from the judge as part of the estate proceeding. And it can be a time-consuming process. So if you're working with a probate attorney who knows what they're doing, be open, communicate with them right away that you're planning to sell, and you get that offer, so you get that court approval and authority request in right away, because you have to wait for a judge to look at that. And they're not going to rush it through as an emergency just because you want to sell next week. You will need time to follow that process. The third thing I look for is whether that estate has removed its tax liability. So again, today, the federal estate tax exemptions are very high, like in the 13 million category. So most people are below that.
Us here. Totally us on this call, 100%. Yeah.
Most people are below that, but I still need verification to say whether that estate, where it falls on the boundary line, because I don't know at all. So the examining attorney is going to look to see whether that liability has been removed. The most common way that's being removed today is with a report and inventory. So if that report and inventory has been filed in the estate and says that no federal estate tax return will be filed, then we know that it's clear there. Otherwise, we can look for an affidavit from the attorney verifying that, the probate attorney, because they'll know whether they want to sign their name too. If someone's close to the bubble, we're going to have to ride that out. But if it's clearly very far that they won't have to file any federal estate taxes, typically the probate attorney is willing to sign off on that. And the report and inventory, for anyone who doesn't know what it is a very time-consuming report to prepare and file. So the executor, I'm just going to use that word for now, has 90 days from opening the estate to prepare that. And the report and inventory is indeed an inventory of the entire estate, all assets that they own. So
lots
it's
of pages.
Not something that someone can just whip up and file the next day to get an estate to close. So we need to be very communicative with our probate attorney that we're planning to sell this. Either we need the report and inventory done. If you can't get that done, let's file an affidavit or something else to appease the preliminary or the preliminary title examining attorney that they're going to be satisfied with.
Yeah. And, closing agents, we get stuck with having a lot of these questions and saying, hey, this is what we're waiting for. So I appreciate you saying it takes time, because so many people want us to whip out a miracle and be like, can't you do this tomorrow? Nope. Can't do it. Like, we have no authority in any of these spaces to get that done. So planning ahead, I always say, even before you get an offer, when you are listing a property and you know that somebody has passed away, who's the estate attorney? Let's talk with them. Like, let's have some questions to ask them, because when you do that, you just plan for success for the whole transaction. Everything can then fall into place once that happens too, or know what the deadlines are going to be. So communication is 100% key. Yeah. What is like your number one horror story that you ever have with like real estate succession planning? Do you have like a horror story that you're like, I learned so much from this because this was a disaster?
Really learned so much, but it can be very disappointing and haunting in that people have life events and fail to update their wills or their estate planning as a result of that. Yeah. So the first story that jumps out in my mind when you talk about this is we had a case where a husband and wife were getting a divorce. Very common today, nothing abnormal. But the gentleman did not write a will, if I recall correctly. So especially for family law attorneys, I think they'll remind their clients when a divorce starts that, hey, you should look at updating your will, your powers of attorney. Sometimes I will see knowledgeable family law attorneys go so far as to change the title in the home from joint tenancy to tenants in common via a quitclaim deed at the start of a divorce proceeding, so that we get to a 50-50 instead of 100 split. And so something similar happened here. This gentleman was in the middle of a divorce. Our law firm was handling it. And all of a sudden he got in a car accident and died. Oh. And the divorce was not final. So under the law, when you don't have a will, the state of Iowa writes one for you. And if you had a spouse and your kids are all with your spouse, then everything's going to the surviving spouse. Absolutely. So all of a sudden, this husband and wife were divorcing. She got everything. And it can just be very disappointing because as we watched this story play out, we were representing, I think that the firm represented the husband, maybe, whatever it was, or we found out about it after. I'm forgetting the details because I know that the attorneys at my office would have suggested that they write a will and make everything clean. So now I'm like, wait, maybe we didn't represent the family law case. We got it. I think we got it as a wrongful death case with insurance defense after the car accident. So we're hearing this whole story, but you feel bad because as I look at that gentleman, I'm assuming his goal was not for his surviving spouse to get everything because they were in the middle of a divorce. Yeah. But that's just how it is. And there's no way, there's a very, very weak argument to fight that, in my opinion. So that it just is a reminder to us that we are human and anything can happen. So when we have a major life event, we really need to think about planning ahead.
Yeah. Which is the whole premise of this entire podcast. Plan ahead too. Love it. Well, we are ending our podcast with a completely random question that has nothing to do with anything that you have no heads up about. So here it is. What are 3 things you would do if you became invisible, Jen?
Invisible?
Invisible. What are 3 things you would do?
First, I would totally listen in on everyone's conversations like a fly
Love
on the
it.
wall. That'd be great. If I was invisible, I would probably like walk to the front of really long lines and then just show up. So I didn't have to wait in line anymore for anything. Or as a side note, I'm going to make my third one, then being able to like walk to the front of anything. So I could walk to the front of the stadium to watch or to watch the game or the concert and always be in the front row.
Love it. See, I'm going backstage, Jen. I'm not even just staying in the front row.
There you go.
Backstage.
So not rebellious enough to even think that I should go backstage. Obviously, I go to a lot of concerts.
That's why I'm going to need a phone call from a criminal attorney after this, because I'm going backstage too. So
Nobody will know. You're invisible.
Yeah, all of this information was, again, so beneficial to anybody who's in real estate, whether you're, again, looking to buy a house, sell a house, an agent trying to help guide their clients, a lender helping their people plan, when they're refinancing. So all this is, again, super duper great information for anyone to have and to be able to say, this is what I know about it. However, you should contact an attorney too. So get to the right space, somebody who knows it, who does it quite often as well too. So any final words that you'd like to tell everybody?
No, thanks for having me. Yeah, keep in mind, what are the client's goals? Talk to a professional and get them on their way.
Love it. Well, thank you for being on the To Be Real Clear podcast too. We appreciate it.
Thanks, Jen.